Hello everyone, this is Marvin Strong. This week's chapter summary video will be on chapters 23 and 24. Chapter 23 is going to be on the rules governing the issuance of trading and trading of securities. The Securities and Exchange Commission, or SEC, is a federal administration agency that is charged with the overall responsibility of regulating securities and ensuring that investors receive full and fair disclosure of all material facts with regard to any public offering of securities. The SEC also has wide enforcement powers to protect investors against price manipulation, insider trading, and other dishonest dealings. The Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010 is a United States federal law that places regulation on the financial industry in the hands of the government. This was signed into law by President Barack Obama on July 21st, 2010. The Sarbanes-Oxley Act of 2002 is a federal law that established sweeping auditing and financial regulations for public companies. The lawmakers created the legislation to help protect shareholders, employees, and the public from accounting errors and fraudulent financial practices. Security is a stock, bond, or any other instrument of interest. It represents an investment in a common enterprise with reasonable expectations of profits derived solely from the efforts of those other than the investor. Chapter 24 is about the antitrust laws. A trustee is an individual person or member of a board given control or powers of administration of property in trust with a legal obligation to administer it solely for the purposes specified. A trustee holds or manages cash, assets, or a property title for a beneficiary. The trustee has a fiduciary duty to act in the best interest of the beneficiary. In many cases, trustees make sure that assets held on behalf of individuals or companies are not misused. Approved July 2nd, 1890, the Sherman Antitrust Act was the first federal act that outlawed monopolistic business practices. The Sherman Antitrust Act of 1890 was the first measure passed by the U.S. Congress to prohibit trusts. It was named for Senator John Sherman of Ohio, who was a chairman of the Senate Finance Committee and the Secretary of the Treasury under President Hayes. Section 1 of the Sherman Antitrust Act prohibits agreements in restraint of trade, such as price fixing, refusals of a deal, bid rigging, etc. Section 2 of the Sherman Act makes it unlawful for any person to monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade, either foreign or domestic. A horizontal restraint of trade is an agreement that in some way restrains competition between rival firms competing in the same market. Any restraint on trade created by agreements between firms at different levels in the manufacturing and distribution process. Horizontal allocations of territory are per se illegal under Section 1 of the Sherman Act. Vertical restraints of trade can be related to price. It can be in the form of tying agreements and can be in the form of allocating customers and territories. The vertical restraints of trade can also come in the form of exclusive dealing agreements. The Clayton Antitrust Act is an amendment passed by U.S. Congress in 1914 that provides further clarification and substance to the Sherman Antitrust Act of 1890. The Act focuses on topics such as price discrimination, price fixing, and unfair business practices.